Hello, my name is Richard Albert, and I'm here today with Rohan Alva, an assistant professor at Jindal Global Law School in India, and also the director of the Center for Public Law and Jurisprudence. And today, Rohan is joining us to talk about developments in Indian constitutional law. Rohan, hi, thank you so much.
Thank you, Richard.
So, Rohan, can we begin with judicial review in India? We all know, or those of us who do comparative public law know, that the Indian Supreme Court has vast powers when it comes to judicial review, powers that in some cases it has arrogated to itself, most notably with the basic structure doctrine. What are some of the newer developments in judicial review in India?
Well, Richard, the basic structure doctrine is, I think, the most famous example of the Indian Supreme Court aggressively engaging in judicial review, where it goes beyond what some consider the mandate of the Supreme Court and reviews amendments and then tells Parliament whether it's right or wrong in passing those constitutional amendments. There are different kinds of uh, practices adopted by the court. One of them is that it reviews legislation and then, under the principle of deference, decides not to invalidate it but merely expresses some misgivings with it. The important kind of review which I am trying to look at is a form of review in which the Supreme Court identifies a situation in which either a law has been made and it is inefficient in respect of a particular right that it has been made for, or there is a situation in which no law has been made, and as a result of no law having been made, there is a situation where individuals have their rights violated. So there are a series of cases from the 1970s in which the Supreme Court, in these special situations, has decided to either instruct Parliament to make certain laws on particular aspects so that fundamental rights can be protected, or reviews the nature of the laws as they currently stand and then give recommendations to Parliament as to how they can be improved upon. And this has worked in several respects. It has worked, for example, most famously in the case of the rights of street vendors, where the Supreme Court very famously gave a particular date by which Parliament should have made a law for the rights of street vendors, since no law had been made by Parliament on that particular point. So I think it's quite interesting that there are situations in which the Supreme Court will really take the step forward and try and inform Parliament of the need for making a law and then actually ask it to make a particular law.
So the Indian Supreme Court is instructing Parliament to pass a law according to certain specifications drawn by itself, by the court.
Correct. Either certain specifications, and then it tells Parliament the kind of law which would be appropriate. And sometimes, until the particular law has in fact been passed by Parliament, the Supreme Court creates guidelines which will operate in that field until and unless a law in that respect has been created.
So from my perspective here in the United States, that would raise concerns about the separation of powers. Is that so in India?
It has raised concerns over separation of powers, but today we are seeing a new kind of trouble, and that is the creation of specialized tribunals for certain forms of adjudication. And the tussle really has been, can the government create adjudicatory mechanisms which encroach upon the jurisdiction conferred on the High Court and the Supreme Court? And this is a very important issue because, unlike I think many other jurisdictions, the Indian Constitution has a specific provision which requires the state to be separated from the judiciary. So separation of powers is in fact a crucial constitutional goal that has to be achieved by the government and Parliament. What has happened is that for certain specific zones of adjudication, special tribunals were created. But the way in which the tribunals were created, they ended up eating into the jurisdiction of the High Court and the Supreme Court. And this was a new kind of difficulty that the court was facing, because rather than the state marching in and taking the court over, it was creating tribunals and then cloaking them under the protection of law. And then the question arose whether these legally created tribunals could in fact operate as a adjudicatory mechanism in replacement of the High Court. So this is a new form of difficulty that we have witnessed, where tribunals are created, alternative forms of adjudicating bodies are created, and the question arises: can the government in fact create adjudicatory bodies and then instead replace the High Court?
A lot of the controversies in Indian constitutional law seem to center around the Supreme Court itself. One of the things for which the Indian Supreme Court, and indeed the Indian Constitution, is known for is its protection of socio-economic rights. What's the latest on that front?
Well, since the 1980s, the Supreme Court, as many commentators have noticed, embarked on a project where it would try and protect as many socio-economic rights as it could. And this was a project that it undertook in light of the Constitution's clause on the right to life, Article 21. So under the right to life, it sought to protect multiple socio-economic rights. One of the major problems that the court faced was that after it adjudicated on a socio-economic right, how would the judgment or the decision of the court be implemented? So in my view, the Supreme Court created two ways in which it could regulate the implementation of the judgment. One would be where it would give an outright direction to the government that certain steps must be taken in respect of a right. Or the second step, what is called the continuing mandamus, is that it gives a particular judgment and then it begins to itself oversee the implementation, or it allows some individuals to act as commissioners who oversee the implementation and then report to the court as to the state of the judgment being implemented. This has resulted in several problems because what has ended up happening is that even after the Supreme Court, for example, supervises the implementation of its decisions, nothing much really happens. And that's been a great difficulty that the court has faced. So I think in terms of socio-economic rights, an emerging area of challenge for the court is going to be how it can craft a remedy in which a socio-economic right is not only recognized, is not only developed, is not only infused with content, but also a mechanism is created for its proper implementation and observance. So one of the ways in which perhaps it could do is to identify certain entities or statutorily created bodies which could perhaps assist the Supreme Court quite regularly in the implementation of its judgment. Because they may, for example, have access to resources which ordinary individuals or retired judges who are sometimes appointed as commissioners may not have. So I think that is going to be an emerging area for the Supreme Court to look into and try and craft newer forms of remedies so that implementation of the judgment can be achieved.
Just one follow-up question on that. Do you see that as assuaging or exacerbating problems with the separation of powers?
In some senses, I think the way in which the Supreme Court understands separation of powers in the case of fundamental rights is that if it identifies a situation in which the right is being violated, it considers it necessary for it to give the best kind of remedy for the enforcement of the right. It then sometimes doesn't engage in debates of whether it is crossing the line or should it be observant of the separation of powers and not give a strong remedy for the socio-economic right. So my reading of the decisions has been from the 1980s, even recently, is that the moment the Supreme Court identifies that the right has been violated, it then begins the process of crafting a unique form of remedy depending upon the right in question, and then trying to ensure that the remedy is actually implemented.
So I guess perhaps one could describe that as the ends justifying the means. Another question. I remember when I was a student in the United Kingdom learning about comparative public law, we read a number of cases from the Indian Supreme Court, and these cases were hundreds and hundreds and hundreds of pages and so rich in detail about comparative constitutional law, how this country answers the question, how that country answers the question. And so it was such a rich resource for us to learn about the comparative enterprise. Has that continued to be the case in India through today?
Uh, I teach civil procedure currently, and when I look at some of the leading cases of the Supreme Court, many of the cases that the Supreme Court follows, in fact, are British cases. And in the realm of constitutional law, that has also been a conscious practice. Regardless of the provision that it is analyzing, it always looks to different jurisdictions to learn from those countries and try and see how best the Indian constitution is to be understood. One of the recent examples of comparative constitutional law, in fact, being rejected and without good reason was the Nas Foundation judgment of the Supreme Court. And this was a judgment which was an appeal preferred against the Delhi High Court's judgment. And the Delhi High Court's judgment had in fact ruled that the Constitution must recognize same-sex rights, and in doing so, it relied on judgments from various jurisdictions, including, for example, the United States and South Africa. When it went to the Supreme Court took, in invalidating the decision of the High Court, quite outrightly rejected the use of comparative law. And in fact, they said that comparative law might not be of critical importance when it comes to understanding whether such rights must be protected by the Constitution. I think this was inconsistent in two ways. One, it was inconsistent with the Constitution itself because there are many provisions which require, for example, the appreciation of international law. So, as a rule, usually the Supreme Court has always looked either at international law or comparative constitutional law to identify the meaning of a constitutional provision. The second nature of the inconsistency, which has also been highlighted, has been its internal inconsistency between the decision of the Supreme Court in certain aspects where it has relied extensively on comparative law as compared to the NAS Foundation decision where it decides that comparative law should not be relied on since it can add no meaningful value to the understanding of the Indian Constitution. So I think there were certain shortcomings in the way in which the court rejected comparative law. Across the world, there are debates over whether countries must look to comparative law or whether countries must not look to comparative law, but those are reasons which justify either of the arguments. But here, there was no sophisticated justification why the court would refuse to look at comparative public law, which just exacerbated the problem further.
And what has been the response to the NAS Foundation case in India?
Oh, the NASFA, it was, I think it came in for universal condemnation. In fact, news channels were waiting from the morning until the judgment would be announced. I think some articles have also been written on the way in which the Supreme Court rejected the use of comparative public law in terms of identifying the importance of same-sex relations. And I think one aspect that the court missed was that across the world, wherever same-sex rights are now being affirmed, at some point in time in history, same-sex rights were expressly denied. So there has been a transformation that has taken place, in my view, in various countries which are of immense importance in order to understand why there is an evolved understanding of same-sex rights and the Constitution. So purely in terms of a historical lesson to see why countries which at one point of time, for example, England, because the Indian Penal Code was a British law and it continues to remain on the statute books, why in that particular country same-sex rights are no longer seen as criminal offenses, why must we continue to see same-sex relations as something which does not, or which is not entitled to constitutional protection? So I think this transformation in terms of constitutional sensibilities for same-sex relations would have been of immense importance to the Supreme Court, and by virtue of not looking at comparative public law, I think it missed that opportunity to engage in that exercise.
For those who study comparative public law and read or write about India, I think there are a few things that come to mind. The first, of course, is the vast powers of the Indian Supreme Court. The second might be the promise and pursuit of socioeconomic rights. But a third would certainly be access to justice. There are long and perhaps increasingly long delays for people to get their cases heard in India. What explains that, and what are some possible solutions to that?
Oh, that's a good question. In fact, the problem of cases just piling up at every level of the judicial system has really thrown up a huge challenge, which even the Supreme Court is trying to figure out how it must solve it. Because there is a sheer number of cases, and the time that it takes to dispose of a case has meant that for many, many individuals, justice is actually denied. Just by waiting for a case to be heard, they are in effect denied justice. So there are two sets of problems which arise. The first is the sheer number of cases that are filed at every level. There are thousands of cases, for example, pending in the Supreme Court on a number of legal issues, but there are thousands and thousands of cases which are really placing a burden on the ability of the Supreme Court to discharge its responsibilities and adjudicate well. The second problem within the Indian legal system, which I think may be looked into, is the particular laws which are created. They have the potential of stretching out the trial, for example, of a case for so long that it ends up hampering the pursuit of justice. So there are time periods, for example, within legislation which, which require certain steps to be taken, and the multiplicity of steps that have to be taken, with each step requiring a certain time frame, just adds to the problem because a case might have to first go through a pre-trial process where a number of steps are taken by each of the parties, and then ultimately the case is adjudicated on. So I think there are laws which allow for a case to drag on for many years, as well as the sheer number of cases which have placed this burden on the courts. And this is in fact an interesting problem because in order to solve the arrears of cases, the problem of arrears of cases, the government decided to create tribunals, special tribunals which would adjudicate these cases. But those special tribunals, when they were created, sometimes crossed the separation of powers borders, and they ended up encroaching on the powers of the High Court, and then they had to consequently be invalidated, as was recently in a constitutional bench judgment of the Supreme Court. So this is really a complicated problem because whenever the government tries to solve it, it runs into some sort of constitutional issue, which sometimes it is unable to cross.
Hmm. In addition, Rohan, to thinking and writing about all of these issues that we've been talking about today thus far, you also have a very particular interest in children's rights in India. So could you tell us a bit about that? What are the issues that you think about and read about and write about in connection with children's rights in India?
Well, juvenile justice in India, the current law which governs juvenile justice in India, adopts a uniform approach in terms of treating children who commit offenses. And the rule is if you are below 18 when you commit the offense, you cannot be treated under the adult criminal justice system, you can't be remanded to an adult prison, and you have to be treated under a special court that's created only for children. But increasingly, there has been a huge public debate in terms of whether that particular age must be reduced from 18 to 16. That is, children between that particular age group should in fact be sent to the adult criminal justice system and not to the special juvenile courts. And this dispute, in fact, has reached the doors of the Supreme Court on several occasions. And even the Supreme Court has now sought to inquire from the government as to the steps that it is taking in terms of reformulating its approach to juvenile justice. So, one problem is that generally there is a perception that children should not receive favorable treatment if they commit certain crimes which are considered serious. But the second issue is, which is interesting, is that the court may have some misgivings with the Juvenile Justice Act. But if it finds that the Juvenile Justice Act has been violated, it comes down very heavily on the police and the investigating team and on the government. So, in fact, it tries to remedy the situation as quickly as it can and as well as it can, even though it might have some misgivings with the act itself. So an interesting example again is of the Delhi High Court, where numerous examples were brought before them that hundreds of children were literally being sent to the adult prisons rather than being taken to the juvenile homes. And the Delhi High Court came up with what is now called an age memo, which now mandates that every police officer who treats a child who is accused of committing an offense must engage in a detailed inquiry about the age of the child, so as to ensure that even by accident a child is not remanded to an adult prison. Something like this has happened in criminal jurisprudence in a Supreme Court case which is called the arrest memo. So in order to prevent police arbitrariness at the arresting level, the Supreme Court created an arrest memo, which would be a document filed by the arresting officer regarding the circumstances in which it effected arrest. Something similar has now happened in the field of juvenile justice. So I think even though there might be some misgiving or some criticism of the law, whether it must treat all children below 18 under the law and whether there has to be some change to the law, if it finds that there has been some violation of the law and a child has been treated unfairly, the courts act very, very quickly to remedy the situation.
In your research into children's rights, are you drawing on any other jurisdictions? Are you taking a comparative approach to this project?
A comparative approach is quite interesting because the Indian law is quite unique in the sense that it adopts a uniform and standardized approach for children. There is no possibility, for example, of a child being sentenced to life imprisonment or being given the death sentence depending on the crime. There's no possibility of a child being sent, for example, to an adult prison system if the court feels that the circumstances justify it. I'm looking at comparative law to see what has been the evolution of children's rights in different countries and how they have come to understand crimes committed by children and the appropriate treatment that the law must provide for it. But my experience really has been that the Indian law in itself is quite outstanding, but the comparative law really informs us as to what has been the evolution of juvenile justice in India.
Rohan, how did you become interested in comparative public law?
Well, this was something that I discovered in my university days because public law is a very, very important field in India. And most important commentators in law happen to be commentators in the field of public law. So my interest was really sparked by watching many of the commentators speak, by reading some of the articles that they'd written when I was just a student and I was trying to figure out which aspect of the law I would be drawn to, which aspect of the law I would be interested in. So it was multiple individuals who really helped me. My university teachers, for example, both at home and abroad, really helped me shape my interest as well as understanding of the importance that we must place on comparative public law and comparative law.
And who are or were your academic and scholarly influences?
Uh, in India was my professor Kamala Shankaran in the United States it was my professor Michael Klarman, and these were the two professors who I really enjoyed. I'd also taken courses in comparative law with Vicky Jackson and the dean of Harvard Law School. So these were some of the courses which really sparked an interest as to how we must approach the law in a setting where we can understand the value of public law for a decent life and how we must construct public law so that it can help individuals live a decent and proper life.
Hmm. Well, thank you for this, Rohan. This has been really, really fascinating as you've explained to us some of the current controversies in Indian constitutional law today. Thank you so very much.
Thank you, Richard. It was a pleasure.
Bye bye.